For decades, the CCAA was seen as the debtor in possession regime. The company in trouble would realize it was sinking, seek court protection, and then propose a plan to its creditors. But as we move through the middle of 2026, that landscape has shifted. We are now seeing creditors and even equity investors seizing the wheel. Whether you are a secured lender in the GTA or an investor looking to protect a failing portfolio company, understanding this creditor-led era is essential. It's no longer just about waiting for a proposal. It's about taking proactive steps to preserve value. In May 2026, the Alberta Court of Appeal released its decision in Angus Manor, a case that has sent ripples through the Canadian insolvency community. The court determined that, in specific circumstances where management is deadlocked or the board is failing to act in the face of imminent insolvency, equity investors can have the standing to initiate CCAA proceedings. I am Avatar Ira Smith, president of Ira Smith Trustee and Receiver, Inc. Right now, Ira and Brandon Smith are helping entrepreneurs and consumers in the GTA with financial issues just like you. If you have any questions at all, either about this Brandon's blog or anything else at all, shoot us a message, give us a phone call. We would love to speak with you. I hope you can watch until the end of this video, and we hope that you find the information useful.
People ask us, please explain the rise of creditor-launched CCAA proceedings. Well, buckle up, because in today's explainer, we are diving into a massive tectonic shift in Canadian insolvency law. For decades, the rules of the game were super predictable. But as of 2026, the whole power dynamic has flipped upside down. The days of a failing company casually steering its own fate while its creditors sweat in the back seat just hoping to get paid, yeah, those days are totally gone. Today, we're unpacking how creditors and equity investors are literally grabbing the keys and taking extreme, proactive steps to protect their cash when a company starts to tank. Here is our roadmap for today. We're covering the power shift, investors take the wheel, the rise of super monitors, surgical precision with RVOs, the need for speed, and finally, BIA versus CCAA. And just a quick note before we jump in, all the incredible insights we are going over today are sourced from Ira Smith Trustee and Receiver, Inc., a licensed insolvency trustee firm in Vaughan, Ontario. Let's get right into it. Section 1. The power shift, from debtor to creditor. For the longest time, the Companies Creditors Arrangement Act, or CCAA, was totally run by the debtor. The old model was simple, but honestly super frustrating if you were the one owed money. A company realizes it's sinking, the executives voluntarily ask the court for protection, and eventually, on their own sweet time, they propose a plan. But welcome to the 2026 CCAA landscape. Now, creditors and equity investors are the ones seizing control. You don't have to wait around for a paralyzed management team to drag their feet while the company's value drops to zero. You can step up and proactively preserve that value yourself. So what does it actually take to force this kind of aggressive move? $5 million. If a company is completely insolvent and a creditor is sitting on a claim over that $5 million threshold, boom, that creditor can go straight to the court and forcefully push the debtor into CCAA protection. It's a massive stick to carry in the business world, and with market pressures constantly mounting, creditors are absolutely swinging it rather than just watching their money vanish. Section 2. Investors take the wheel. The Angus Manor decision. Imagine this nightmare scenario. You have poured money into a promising company, but things go south fast. The business is bleeding cash, the board of directors is completely deadlocked, and they are just sitting there paralyzed while your investment burns to the ground. Historically, you were stuck on the sidelines. You couldn't force a restructuring. You just had to watch the fire spread. But guess what? The legal landscape just handed investors a massive fire extinguisher. In May 2026, the Alberta Court of Appeal dropped the landmark Angus Manor decision. They ruled that when management is hopelessly deadlocked or failing to act, equity investors can officially qualify as interested persons under the CCAA. This is absolutely huge. It legally gives equity investors the power to step right out of the shadows, override a paralyzed board, and kickstart corporate restructuring proceedings themselves. This ruling is a literal game changer. It creates a brand new, legally recognized safety valve. For business owners and stakeholders actively managing huge portfolios, this stops that totally dreaded burn-down scenario in its tracks. You are no longer a helpless spectator. You now have a court-backed lever to pull so you can step in and fight to save the business when the company's own leadership won't lift a finger. Section 3. Rise of Super Monitors. Unprecedented Oversight. Because creditors and investors are aggressively launching these proceedings now, the court had to seriously level up its oversight. Traditionally, a monitor was just the court's eyes and ears, basically writing reports while management still ran the show. But now, welcome to the era of the super monitor. This is a licensed insolvency trustee armed with supercharged operational powers. It creates this wild legal hybrid where the company gets the protective freeze of a CCA combined with the incredibly tight operational control of a hardcore corporate receivership. So what makes them so super? Well, they aren't just watching, they are actively doing. Super monitors can literally approve all major expenditures before a single dime leaves the bank account. They direct the crucial asset sale processes, and they can even override existing management on key strategic decisions. Think about that power dynamic. If you are a creditor who has lost all faith in the leadership team, this super monitor is basically your new best friend, making sure your interests are actually protected. Section 4. Surgical precision with RVOs, preserving intangible value. Let's talk about the RVO, or Reverse Vesting Order. This is arguably the most powerful and heavily scrutinized tool in the modern restructuring toolkit. Instead of just buying a dying company's physical assets, a purchaser buys the actual shares of the distressed company. Now, you would think they'd inherit all that crippling debt, right? Nope. The court literally orders all the bad stuff, the toxic contracts, the massive historical debts, to be magically vested out into a temporary, bankrupt corporate shell. Think of it exactly like buying a used car. A traditional asset sale is like selling the physical car and leaving the old bank loan with the old owner. Clean break, but you need new plates and new registration. An RVO is completely different. It's like keeping the exact same car with the exact same registration and license plates, but a judge steps in and magically wipes the massive debt clean off the title. The structure stays perfectly intact, but all the heavy baggage is totally gone. Why go through this crazy legal obstacle course? It is all about saving intangible value. If a company holds a highly regulated license, like for large-scale cannabis or a strict pharma patent, transferring that in a traditional sale can take months or even years of regulatory red tape. In an insolvency, you literally don't have that kind of time. An RVO bypasses the nightmare entirely because the corporate shell stays the same. The license never legally changes hands. Now, judges definitely heavily scrutinize this, so it's not used as a sneaky shortcut to dodge obligations. You need rock-solid proof it's necessary, but when it's approved, it is brilliantly effective. Section 5. The need for speed. SISPs on steroids. To actually save a distressed business, you use a SISP, a sale and investment solicitation process. At its core, this is the formal, court-approved way to aggressively market a company's assets to global buyers. But the speed of a modern SISP has gone absolutely next level over the last few years. 45 days. I really want you to let that number sink in. Think about how long a healthy company takes to buy another business. Months of deep due diligence, endless boardroom meetings, mountains of legal paperwork. Now compress all of that into just a month and a half for a massively distressed asset. That is the reality today. Experts are calling these SISPs on steroids. Teams are literally launching the process, marketing globally, fielding bids, and fully closing complex corporate sales in as little as 45 days flat. Why the breakneck speed? Because time is the ultimate enemy of value. Every single day a company sits in protection, it is burning through hundreds of thousands of dollars in lawyer and monitor fees. Plus, rumors spread, and you start bleeding your most important, nervous customers. When you are insolvent, speed isn't just a preference, it is survival. You need a deeply networked, incredibly decisive restructuring team that can move at absolute maximum velocity. Section 6. BIA versus CCAA, a strategic comparison. When you're navigating distressed assets, you basically have two main paths to choose from, the Bankruptcy and Insolvency Act or the CCAA. Choosing the right one is everything. The BIA is your go-to for straightforward liquidation. If you want strict, rules-based control where a receiver just steps in, sells the assets, and shuts the doors fast and affordably, pick the BIA. But the CCAA? That is a totally different beast. It is built for massive, going concern restructurings. If you've got over $5 million in debt, need the profound flexibility of court-driven RVOs to save patents, and want to leverage those new equity shareholder rights from the Angus Manor decision, the CCAA, carefully guided by a super monitor, is absolutely where you want to be. So the debtor is officially out of the driver's seat. As creditors and equity investors grab the wheel with unprecedented power, is your company actually prepared for this new proactive reality? Or will management just sit paralyzed until that $5 million threshold forcefully strips away their control? It is a brand new era of corporate restructuring, and knowing exactly which legal levers to pull is half the battle. If you have any questions, call either Brandon or Ira Smith today.